Let's talk about business bankruptcy. So, with the economy the way it is, there's probably going to be a fair number. There already is an increasing number of bankruptcies taking place, both individually and businesses. So, what exactly happens in a business bankruptcy, or what does that mean? So, if you're an owner of a business, you might be concerned and you're struggling, that business is struggling, then you're considering, okay, should I file bankruptcy for the business? How does that work for my personal credit or the business? Or if you're owed money. So the way that things are going in the economy right now, this guy owes me some money. He hasn't been paying. It's been several months. What's going on? I hear they might be filing bankruptcy. What should I do? So let me share my screen and I'll show you first the most common types of bankruptcy that you can file. Now, on the left is Chapter 7. This can be filed by a business or an individual, and it's a complete liquidation of assets. That means closing, if you're a business, that means closing your doors. I'm not going to talk about individual, but basically that means that Chapter 7 means the company's shutting down, they're closing their doors. They are effectively turning it over to a Chapter 7 trustee or some other individual third party that's going to take the keys essentially and look at what are the assets and look at their balance sheet. What are the assets? What are the liabilities? What can I sell and how much can I get for it? And then how do I pay people out? So usually that's based on priority of who's owed money. And usually the top of the food chain is going to be a secured creditor or a priority claim. The bankruptcy will segregate those. Priority claims are usually higher than secured claims. Unsecured claims just depends on the type of priority, where it fits in the stack, but secured could be higher or lower than priority. Normally you look at, okay, what are the priority or administrative actually comes before that, but I don't want to get into too far into the weeds. But the administrative costs, like of the bankruptcy and the trustee, will get paid out first. Then we look at, okay, what are the priority claims? What are the secured claims? Priority would be things like taxes, payroll, you didn't pay your employees that you were supposed to, taxes, those could be a priority claim. Those are usually going to get paid out early, if not first. Secured claims, those are the claims where you owe someone money where it's secured against an asset, meaning think about your car. So if you have a loan on your car, the lender usually has a lien or some type of protection that if you don't pay, they can repossess your car. They have a security interest in the collateral, and that's a secured claim, a secured creditor. Same thing with a house. If there's a mortgage on it, they have a deed of trust or a mortgage that's recorded. If you don't pay, they can go in and take your house. So the collateral asset is secure. Those are usually going to get paid out first. Then after that, usually it starts coming down to like unsecured creditors. These might be loans that were taken out, credit cards, other expenses of a business that are not necessarily secure. They're just general money that's owed. And if there's money left over after you've paid 100% to everybody, let's say you pay off your taxes, you pay off all your debts, you pay off unsecured, secured, everybody, and there's money left over, then the equity owners of the business, whoever owned the business, could get some additional money, whatever's left over. It's pretty rare, but usually if there's going to be money left over, you're probably not going to end up in a bankruptcy. You'll figure a way out, just the way it works out with if you have equity there. But if you do a Chapter 7, basically liquidate everything, pay everyone out, whatever's left, if anything, would go to the owner. In the middle, I have Chapter 13. Now, this is only for individuals, so I'm not really going to get into it too much in this video because we're talking about business bankruptcy. And then on the right is Chapter 11. Chapter 11 can be filed actually by an individual, but you'll usually hear about it when it's a business. It's a reorganization plan. That plan could be a liquidation plan, could be just like a Chapter 7, sell everything off, pay off the creditors in their priority. And if there's not enough to pay everyone in full, then we look at who gets paid first and then pro rata split it between your creditors so everything is fair. So that's like a liquidation plan in a Chapter 11. Could be a restructuring plan where maybe you try to negotiate new terms with the lender and you get, so for example, you're in a little bit too much debt, but you're still making money. You go to your lenders in a Chapter 11, it gives you a little bit of breathing room because you filed the bankruptcy. They can't take action against you, but you can continue doing business and making money. Meanwhile, you're renegotiating with your creditors saying, hey, if we can renegotiate and push the payment terms out from 5 to 10 years, drop the interest rate, something like that, and we'll be able to pay you off in full. So the Chapter 11 is a lot more complex and costly. That's usually when you hear the news about so-and-so large corporation filed Chapter 11. Usually those are restructurings to keep the business going, but they can also be a going out of business, essentially. So it really makes a difference if somebody says, I want to file bankruptcy, or this guy owes me money, or this company owes me money, and they filed bankruptcy. You need to find out what type of bankruptcy they filed. If it's a Chapter 7, then there might be a little chance of getting your money out. If it's Chapter 11, there's probably a better chance to try to get your money that you're owed out, because that could be a restructuring where they pay part of the debt, potentially. I mean, here's just an example. This slide is some of the largest bankruptcies in history. Now, these are individuals. Henry Ford, $2 billion bankruptcy in 1901. So it's pretty common. Even large, very, successful people have filed individually. Donald Trump, our former president, 1.1 billion due to some real estate issues primarily. And Mike Tyson. There's a number of different people on here. And then if you look at what are the largest corporate bankruptcies, I haven't looked at this in about 2 or 3 years. I don't think there's anything bigger than this, but as of when I put this together, Lehman Brothers was the biggest. What is that? 691 billion. So over $500 billion. Washington Mutual. So this was the 2008, basically, after the market broke down in 2008, 2009. Washington Mutual, Lehman Brothers all went out of business. Some of these others were, Enron was a little earlier than that, 2001. So some pretty big bankruptcies. Some of these stayed in business. Most of them went out, like, let's see, General Motors obviously stayed in business. I think CIT Group did stay in business. There is still a CIT around. Chrysler, but a lot of these also went out of business. So they may have filed a liquidation plan. So if you're potentially thinking about filing bankruptcy for your business, you have to figure out who is the one filing bankruptcy. Is it you individually? Or is it, if you have a corporation or an LLC, is that the one that's filing bankruptcy? Because the legal entity could be the one filing bankruptcy. So if all your debts, your contracts, everything, you've been around a while, you have a corporation, all your contracts, all of your loans, they're all in the name of the corporation, then you might be able to just file bankruptcy for the corporation to eliminate debts or restructure them. However, most of the time, I mean, I've done a lot of these over 20 years, and a lot of the times when people come to me and say, let's file bankruptcy, especially like 2008, 2009, 2010, when things fell apart, I filed a lot of these. The business owners might have an LLC or corporation, and so they say, okay, well, all the debt's in the name of the company, I'm good, right? Unfortunately, most of the time when we looked into it, they all had personal guarantees. So a lot of those loans that they had built up, the lenders took personal guarantees or leases, loans. A lot of those end up, you have a personal guarantee. So you have to be very cautious. If you're filing bankruptcy for your corporation, and you're the owner, you want to check and make sure, hey, did I ever sign a personal guarantee? Because eliminating the business debt at the corporate level doesn't keep them from coming after you on the personal guarantee. So you can wipe out the debt against the corporation, but that debt they can still enforce against you personally if you have a personal guarantee. That's the whole point of it. That's why they put those in there. Or there could be a corporate guarantee from a parent company down to a subsidiary. So you have to look at all this stuff to see, okay, if we file bankruptcy, can they come after somebody else, or is this going to be a clean break and a fresh start? Now, if you're owed money from a bankruptcy, or from a client, like somebody that owes you money, and you heard they're filing bankruptcy or they're thinking about filing bankruptcy, again, you have to be very cautious, because if you, oh my gosh, they're about to file bankruptcy, I better get my money out now. If you go in there and they say, yes, that $100,000 that we owe you, we're going to pay it all right now, and 45 days later they file bankruptcy, you think, okay, I'm good, I got paid. Unfortunately, the bankruptcy code allows the trustee, who's kind of a person appointed to oversee the case, the power to come after you. So the court could look at it as, there's all these other creditors, you forced them to pay you $100,000 to take care of you, but you deprived all these other creditors that could have had part of that. So they may force you in a clawback action to pay back some, if not all of that money. And then they're going to decide, okay, out of that 100,000, you're going to only get 1,000 because of all these other people that are owed money. So it's not a bad thing to be aggressive and pursue it, but understand, just because you got your money back doesn't mean it's safe, especially if they file bankruptcy within a period of time, because there's a look back window. There's a number of them. Some are 90 days, a year, 2 years, 10 years for certain trusts. So in some cases, the trustee does have the right to go back and say, hey, this wasn't fair, I'm taking that money back, and get a court order to force you to turn it over. It's pretty rare, and it's usually only if it was paid like large amounts right before a bankruptcy, but it can happen. Now, if you're owed money, and whether they paid you something or not, you're still owed money and they filed bankruptcy, find out, first of all, when. So if somebody sends you a notice, you should have on the notice, whether they mail it or email it, the information about the bankruptcy. But what you need to know is, okay, what's the case number? Specifically, what court it was filed in. So if it was Northern District of Texas or Southern District of California, what bankruptcy court is the case being heard in? And this will be on all the paperwork if they send it to you. But you need to make sure you know what court the case is being handled in, so you know where to go. Then you want the case number. Usually it'll have the name of the debtor, which is the company filing bankruptcy, or person. So it could be XYZ Corporation is the debtor. And that'll be the case caption, in re, RE, in re XYZ Corporation, debtor. And then it'll have a case number, where it's filed. And for example, in most Chapter 11 cases early on, they're going to set what's called a claims bar date, and they'll send notice of this. What that means is, essentially, hey, Mr. Creditor, I know this company that just filed bankruptcy owes you money. So I'm going to give you until December 31st to file a proof of claim with the court that says, yes, I'm owed money, here's how much, and here's some proof of why I'm owed money. Invoices, contract, something that you have that shows that you're owed the money. And they'll usually send notice saying there's a claims bar date, make sure you get your claim in. Same thing in Chapter 7, but usually Chapter 11, it's more of a formal process, but you need to pay attention to what's called a claims bar date. If you don't get your claim in by that date, you may not be able to get paid out, even if you're owed money. Even if they admitted that they owed you money, you may still not be able to get your money out. So make sure that you file a proof of claim. Most of these can be done electronically on the court's website, the bankruptcy court. So if it's Southern District of California, look up that court, find their website. Most of them have electronic proof of claim that you can file right on their website. And usually you can upload copies of invoices, contracts, that kind of stuff. So you make sure you get that done, and you pay attention to what's happening in the case. Once you've filed your proof of claim, if they dispute it, that's another story. They could say, you know what, I don't think I owe them money, I never signed the contract. Then you're probably going to have to hire an attorney to go into court to argue, whether it's some type of motion, adversary proceeding, to prove that you're owed the money as a creditor. A lot of times in the cases, you file a proof of claim, and if it's pretty clear, it just goes forward that you're owed that amount. But there is a process to where they can dispute your claim. and other creditor, like it gets a little complex, but it's not just the person filing bankruptcy. The trustee, other people can look at it and see, do we want to dispute this potential claim? So assuming that no one disputes your claim and you file the proof of claim on time, at the end of the case, after they have liquidated the assets, classified the type of claims by priority, so like priority, secured, unsecured, and let's say if you're unsecured, which is most of the time what happens, because if you were secured, you would have a collateral to go after, an asset, like a car or a house. But if you're unsecured, like a lot of times happens, it's just a loan, or accounts payable owes me money. So you file your proof of claim saying, here's the contract and invoices. The court says, okay, here's all the creditors we have to pay out. Here's how much is left over. There's $1 million left over in cash. And based on how much is owed, they're going to come up with a percent. And whatever percent you are out of the remaining amount owed, generally is what's going to happen is, let's say 10% of the money owed is my claim. I'm going to get 10% of that $1 million. Not 10% necessarily of my claim, but the pro rata amount of what's left over in the bankruptcy estate in the case. So, okay, I'm going to get paid out 3% or 20% or 100%. And that's something that happens throughout the bankruptcy case to see what percentage is going to get paid out to creditors of what they're owed, depending on what's left over. So a 100% plan essentially means that all creditors are going to get paid in full. And then you can look at whether you potentially can get interest or anything like that. Whatever's under the contract is what you claim. So that's just kind of a general overview of business bankruptcy. And remember, these are very common. You have to look at who owes the money, is there a personal guarantee? So if it's an LLC, is there a personal guarantee? So the bankruptcy may not even help. If you're owed money, make sure you file a proof of claim. These are all things to think about in a business bankruptcy. We're probably going to see quite a few more of these based upon just the way the economy has been going, but that's a general overview of how they work.